I'm just going to tell you very quickly why I think we are here, which is I received sort of a flurry of emails from Mr. Freehoff indicating that Ms. Diallo, originally Mr. Alexander communicated that Ms. Diallo was refusing to sign whatever paperwork, and then I heard from Ms. Diallo's attorneys that no, she's perfectly willing to sign, she just wants to go to the closing, and then there was some confusion about whether there was going to be a closing. And I think what I understand now from the actual closing attorney at Luter Larkin is that there will be a closing. Now, of course, whether Ms. Diallo actually needs to be present for any such closing is an open question because she just needs to sign some paperwork, although it seems like it probably could be accomplished in the context of the closing. But where I think it seems to have broken down is that Ms. Diallo says she will sign, but she wants to attend the closing, and Ms. Kante doesn't want her at the closing or isn't sure there will be a closing. That's what I think I know. Mr. Alexander, you were the one that brought this to my attention, so if you'll let me know where everybody's position is currently, or at least where your client's position is.
Yeah, yes, Your Honor. Of course, we're trying to keep the loan from expiring, but to just get to the chase and have regard for your time, I just emailed to Mr. Freehoff the email that Ms. Mays, the closing attorney, actually sent to them. What Mr. Walker, if you look at his email to Mr. Freehoff, he goes on to state that, oh, I've spoken with the closing attorney and the closing's got to be redone. But what he didn't do, he didn't send you the email because at the end of the email it says that she still needs that deed signed before the closing. See, because all that's it all boils down to just getting this deed signed so the closing can be set up. But and I won't say definitely, but it seems to me that if Mr. Walker wanted to inform the court of what Ms. Mays' needs were, he would have disclosed to you that in that very email that was about their telephone conversation, that she specifically said she needed that deed to be signed before the closing. So it seems like to me that should resolve any differences. And
okay.
Thank you.
Okay, good morning, Your Honor.
Well,
If I can.
Thank you, Mr. Alexander. Yes, Mr. Walker.
So prior to the conversation I had with Attorney Mays, who did advise me that there will be a second closing, my co-counsel, Attorney Blunt, I believe, for that exact email that Attorney Alexander is referring to. So it was not a matter of me trying to withhold information. I was aware that Attorney Alexander had already sent the email to the court. And to go even further, I believe my co-counsel, Attorney Blunt, had sent the same email to the court. So there was no matter of hiding information. That's just not true. In my conversation with Attorney Mays, she did tell me that she put that in the email because they had already had one closing. And as we know, that closing did not go according to plan. And they did not have all the necessary documentation. And that's why the funds ended up getting sent back. So in my conversation with Attorney Mays, she more so said that was just a preference that she had the deed to begin with because she did not want to go through the woes of setting up a closing and then not having all the documentation that was necessary a second time around and we'd be back at square one. So it wasn't that she absolutely had to have the deed prior to the schedule of the closing. It was a matter of preference. But going forward, as I stated, I talked to Attorney Mays and she stated there will be another closing. She said that there wouldn't be an issue for us to attend the closing. Now, she did tell me this information. If we wanted to be in the same room as everybody else, that Ms. Kante would have to give her consent. But I mean, of course, I think I would leave that up to the court. But most importantly, she advised that the first closing is null and void. There will be a second closing as is required, and that we can be there. It might have to be in a second room if they don't agree or give consent for us to be in the same room. But that was the request of our client. She wanted some type of assurance. So I think that she was well within her right to be present. As of right now, she is listed as co-owner of the property. So I don't think this was an outlandish request. I don't know why Attorney Alexander was asserting to the court that there would not be a second closing. We have confirmed I think more than once at this point in juncture that there will be a second closing, a traditional closing, a full closing, not a partial closing. And that was our only request. Attorney May said we could be present, but to be in the same room that will require consent. And that was my last conversation with Attorney May. So that's all I have to report to the court pertaining to the issue.
Thank you, Mr. Walker. Mr. Alexander?
Yes.
Well, hang on, I take it back. Mr. Walker, assuming that Ms. Mays' preference is for Ms. Diallo to have executed the deed before the closing. I guess I sort of have two questions for both sides. Mr. Walker, from your client's perspective, if Ms. Mays' expressed preference is that the deed already be signed, I don't know that I have a problem with Ms. Diallo being at the closing, but I'm not sure I understand why she'd want to if her role in the closing is already fulfilled, right, which is to execute that whatever documents will effectuate the sale in terms of her interest. And the court has already entered an order that it seems as if the closing attorneys have indicated they will comply with, which is to either hold or to forward to the court registry all proceeds of the sale that aren't payment of the lawyer, payment of the real estate agent, et cetera. So I guess my question to you is, why does Ms. Diallo need to be at the closing if Ms. Mays has indicated she wants her to go ahead and execute the deed? So in other words, according to the closing attorney, Ms. Diallo will have already executed those documents. Why does she then need to be at the closing?
Oh, okay.
Mr. Walker?
I'll be glad to answer that. I'll be glad to answer that, Your Honor. So at the time that we had made that request, that was prior to us speaking to Attorney Mays. I didn't get a chance to speak with Attorney Mays, I think, till last Wednesday or Thursday. You know, she did apologize, and she stated that she had been in closings all day for the last few days prior to speaking with me, but we did make that request prior to speaking to her on Wednesday. When I spoke to her on Wednesday, she did state that was her preference, but she did not say that it was a requirement. She did advise that, you know, it is a possibility, or, you know, there is no issue with her coming to the closing to sign the deed. She just simply stated it was her preference because they already had one closing. As we know, that didn't go as planned. So she said, you know, just, it was a matter of preference. To answer your question, we made the request prior to speaking with Attorney Mays, but even after I spoke with her, she just said that was a matter of preference, and it is possible for Ms. Diallo to come to the closing to sign such a deed. Obviously, you know, that's up to the court, but that was our preference and that was our request.
Thank you, Mr. Walker. Mr. Alexander, if Ms. Diallo has indicated that she will execute that document and that she wants to be at the closing, I understand that the entire transaction doesn't really concern her in the sense that ultimately she will have signed away her interest in the property so that it can be sold and that mortgage can be satisfied and she will no longer have a legal obligation. But other than concerns about possible disruption, do you have any problem with Ms. Diallo attending the closing, being present in a different room, if she will sign the, assuming that she's indicated she will sign in compliance with the court's orders, whatever documents are necessary as part of the closing to effectuate the transfer?
Your Honor, I don't have any problems with that. However, I have been informed that the mortgage company does not intend to send the proceeds again until that deed, Ms. Mays has informed them that they have the deed. And one of the things that's going on is because the reason why there even has to be another closing is because the numbers for the mortgage is changing because it did not go into effect. I do want to remind the court, as I've previously stated in one of my emails, the buyer is actually already in the property. So the way that I actually believe that this is going to go on, I don't think that there's a time where everybody's going to come together. I believe that she's going to get the documents, you know, to the real estate agent or to the broker, or whatever, and they're going to get the buyer to re-sign the mortgage documents. Miss Kante has already signed the deed. My understanding, she doesn't have to sign the deed again. But the most important thing, none of this gets started until Miss Diallo follows the court's order and sign the deed. And I don't understand why they won't do it. I don't understand what benefit that they're getting, because, like, as the court has stated, all the money's going that would go to the trust or whatever, all that's going to the court anyway.
Okay. Thank you, Mr. Alexander. I appreciate it.
Thank you.
So here's what I think makes the most sense to me. I think that it would be beneficial for Ms. Diallo to go to the closing attorney's office and execute that document. I don't know that that has to occur at any formal closing, but I do think it should occur ahead of time, because that has been the closing attorney's expressed preference. And so I don't know here's what I'd like. I'd like for the parties to get from Ms. Mays, and you can report it to me. You can send me an email. You can tell me what she said. You can forward me her email directly. But what I would like to know is, if Ms. Mays were going to schedule a closing, you know, what day would it be scheduled for? And then I'd like to order Ms. Diallo to go on a couple of days before, to go to the lawyer's office and sign that document. Now, she doesn't have to, but if she wants to, she can. Go to the lawyer's office. Obviously, if she has the ability to, you know, DocuSign and all that stuff like people do nowadays, she can do that as well and stay at her home. But I think it would be beneficial to Ms. Diallo to be able to go and formally execute the document that she's been ordered to execute. And then if there is a formal closing, then I think that Ms. Diallo is entitled to attend if she wants to, although I honestly don't understand what purpose it would serve if she's already signed the documents that function as her role in the transaction. So does everybody understand sort of what my ruling here is? That my understanding is that the express preference of the closing attorney is that the deed be whatever documents Ms. Diallo has to sign be signed ahead of a formal closing, because the mortgage company has indicated they don't want to fund the loan again and transfer the proceeds. And if that's the case, then, as I said, if the closing needs to take place by the 29th or 28th or whatever of June, then Ms. Diallo has to go on 2 days before that and execute that document. And then if she wants to attend the closing or be present at the lawyer's office when the closing is occurring, again, I'm not sure I understand why she would want to, but she can, to the extent that there is a formal closing.
Thank you, Your Honor.
So I just need to know if hang on one second. So basically, just setting aside the complications of this case, I need an answer from, if the closing attorney were to say, this is all taken care of, I'm going to schedule the closing for X, then I just need to know what that date is. And then I will order that Ms. Diallo go to the closing attorney's office at least 2 business days prior to that date and execute the documents that are necessary. But that if she wishes to attend any formal closing that will be held after that time, then she may do so. Any questions or anything, and who is going to be responsible for getting that information for me in terms of the date of a closing? Mr. Alexander?
Yes, Your Honor.
I don't have any issue reaching out.
I'll get it, Your Honor. Thank you.
Okay.
Sounds like we're both reaching.
Excellent. Well, I mean, there's nothing stopping any party from reaching out. I just wanted to assign one person, because I find it.
Well, I prefer to reach out,
and then it sometimes doesn't get done. So I just want to make sure.
Prior to this, it sounded like Attorney
Well,
Alexander
again, Mr. Walker, I'm not.
Mr.
Mr. Walker, stop. I have no problem with you reaching out to the closing attorney, and you're absolutely authorized to do so. I'm just tasking Mr. Alexander with reporting back to me what information he obtains from the closing attorney as a date for closing. Obviously, if he sends me an email that you don't believe accurately reflects whatever information you've got from the closing attorney, then you can certainly let us know by email that you don't think that's accurate. So again, I'm not prohibiting anyone from speaking to the closing attorney. I'm just tasking Mr. Alexander with reporting back to me about what the date of the closing will be.
Understood, Your Honor. And I do have one question, if it's okay with the court. Attorney Alexander mentioned that the numbers, or correct me if I misquoted you, Attorney Alexander, but you said something about the numbers with the mortgage have changed, or did you say something to that effect?
My understanding is that's what he said as well. But I mean, if you've got to close it again, interest rates close, and I'm aware that things change. I don't know that that changes. That's definitely something that y'all could talk about offline to make sure that you're both understanding what's happening
with the court, because I understand that interest rates may change, and
that's what it is. And also,
okay, I just wanted to make sure that it wasn't the sale price, because obviously the major concern of our client was the money that was initially going into the trust is now going into the registry. That's all. I just want to make sure that there wasn't like a change in sale price, so we don't show up.
Mr. Walker. So just so you understand, I am, just so we're all clear, my order is that no proceeds other than the proceeds of, other than paying lawyers and paying real estate agents and things like that, the traditional costs of a transaction, that all the proceeds, including anything that might have been listed as being paid to the trust, are going to go into either the court's registry or Luter Larkin's escrow account if the parties could agree on that. And the reason I repeat that is, I'll just note, I think Mr. Alexander just said that exact thing, that all those things are all going to be held and will not be paid out to anyone, again, other than a real estate agent or, you know, the costs of the mortgage company or the costs for the closing attorney, that sort of thing.
I understand, Your Honor. I just didn't want it to be an issue of where the sale price had drastically changed, and then all of a sudden, because I believe there's two mortgages on the property, so I didn't want to be like, oh, there was just enough money to cover the two mortgages, and now there's only $5 worth of proceeds going into the registry. So that's what I meant.
Certainly understand, but again, I think those are things that y'all can talk about offline.
Okay.
I don't know that you need me because I feel like my order has already ordered that.
Okay, understood.
Okay, excellent. Okay, well, thank you both. I will wait for later today, no later than tomorrow, for the parties to tell me when the closing is going to be. And once we have that information, then we'll enter a very brief order that says that you guys are required to, whatever day you're supposed to do it. Okay?
Thank you, Your Honor. Thank you so much.
Thank you both very much for your time. I apologize for not joining you better. But I do appreciate your time, and I'll make sure we have an order on file. I'll look for the date for the closing. Okay.
Bless you. Bye now.
Thank you.
Thank you. Bye-bye.